I thought they had quality control.
No comment. Okay, now arbitration. I have this in the materials in case anybody wants it, but I'm going to just push right through this because it's a little too specific for what we're trying to talk about today. But the takeaway on this is that you can arbitrate outside China, you can arbitrate inside China. There are legitimate arbitrable bodies outside and inside. CTEC is the best known one in China.
And do you see a lot of contracts written that way on supply of goods that they actually have arbitration clauses in there?
Absolutely, yes. In fact, in most cases, a well-written supply contract calls for arbitration. What's interesting, though, is that we don't always write our contracts calling for arbitration because sometimes our clients, their biggest concern is not, they're willing to accept that if they get bad product, they're never going to get their money back. So what they're focused on is, their biggest concern is stopping the Chinese company from continuing to manufacture their product and selling it around the world after the American company has moved on to a new manufacturer. And so sometimes we actually call for litigation in China so that we can go to a Chinese court and get injunctive relief against the Chinese company. But most well-written international contracts call for arbitration because there are 159 or 155 countries that will enforce foreign arbitration awards, and there are very few that will enforce a U.S. court judgment.
Do the Chinese government enforce non-parties to go through arbitration?
I don't know. I doubt it very much. The rules are, it has to be, arbitration has to be by agreement. Now, it's my understanding those are the rules generally in the United States as well, but it seems like sometimes parties are pushed. I mean, isn't it true that they're sometimes pushed into arbitration? I've never heard of that happening in China. I doubt that it would happen. Okay. Discovery in China. Let's say you don't want to sue the Chinese company. You just want to find out what happened. You want their documents. You want to talk to their witnesses, to their employees. That is actually possible. It's very difficult. China and the U.S., there are some treaties between the two of them. There are some international treaties that allow for the taking of evidence abroad. China allegedly abides by those agreements, though I defy anyone to find someone who's actually succeeded. China does not allow depositions on its soil, and a lot of countries don't. We have a deposition system here. Most countries don't. Most countries would view a deposition as a foreign court literally coming onto their turf, and they don't allow it. Now, there's a way around that that we have used sometimes. We've actually never used it in China because we've been concerned about using it, and that is if you can get the Chinese witness to agree to be deposed, you can depose them in the U.S. Embassy or the U.S. Consulate because that is American soil. So if you can get the Chinese witness to go to the consulate or embassy, then you can do it there. The way it's usually done, the way it's been done in every case in which I've been involved, is that you fly the witnesses to Hong Kong and then you depose them there. And I think one of the reasons it's done that way is because the Chinese love going to Hong Kong, and that way they'll agree to testify. They also love going to Macau, where all the casinos are, but I wouldn't recommend that. The problem with doing depositions in Hong Kong is it is unbelievably expensive. And doing these depositions is unbelievably expensive. The last time I did one was not all that long ago, and I flew from Seattle to Hong Kong. One of our lawyers in China, an American lawyer who's fluent in Mandarin, flew into Hong Kong, and because we were concerned about the translator, and rightly so, because a lot of the translators in Hong Kong are actually really quite bad, because Mandarin is not even their first language, it's Cantonese. And we stayed at a Marriott that was just your normal run-of-the-mill Marriott, and it was $450 a night, and it was very expensive. So you better think long and hard about who you really need to depose. Now, you can also get documents through letters rogatory under the Hague Convention. I've actually never done that. I've tried to find someone who's actually succeeded at that, and I think I've heard of someone who has, but most of the people I know who have tried it have said, don't bother, it takes forever, and I'm not even sure if it ever works. So really, what you need to do is you need to try to just get the documents through informal means. And sometimes you can do that. I mean, it's interesting, because we've actually had pretty good luck with that, because sometimes these Chinese manufacturers want to help out their suppliers, and so a lot of times they will go to Hong Kong and they will give you the documents. Whoops. Okay, so what are your, now that I've told you all the things you can't do, what are some of your options? Well, I talked a little earlier about Korea. These are some, Korea, England, Canada. I think it's true of England. I know it's true of Canada. Canada and Korea will enforce U.S. judgments. And so if you're suing a Chinese company that has assets in Canada and does not have assets in the United States, or they have assets in Korea and they do not have assets in the United States, you should seriously think about taking your judgment to one of those countries, because it is possible to enforce it. Now, Canada, you would think, would be the easiest, and it is actually quite easy. But Canada does not like default judgments, and they do not like default judgments if you haven't followed every single rule, so that makes it somewhat difficult. Korea can be an amazing country. It's the best country I know of to seize assets. The courts there, I have a Korean lawyer friend who always says, easy to arrest, hard to release. And that's the rule in Korea. And the way it works in Korea is you can take a U.S. judgment and seize $200 million worth of assets. And, I mean, I've done this, seize $200 million worth of assets, and the bond costs $20,000. And then you can require the other side to post a cash bond that completely covers you. And so you can seize $200 million worth of assets, and if the other side wants those assets released, they have to post a $300 million cash bond. And who has that kind of money? And then once you're in litigation in Korea, you never get out. I mean, it just goes on forever. They have a civil law system, and I always say, I had a revelation one day that the way the Korean courts always base their decision, what they always base it on is what is good for Korea. And so after I had that revelation, my record of picking how a Korean court is going to rule is better than courts anywhere else in the world. And the way they're going to always rule is for the case to continue. And that way the Korean lawyers can keep making a lot of money. And that's fine for you because you've got $20,000 sitting there. That's not so fine for the other company that's got its assets completely tied up. And so Korea, if you can seize assets in Korea, at 90% of the time the case will settle within a month or two because the defendants get so desperate. And it's only the not very smart ones that try and fight you, and then they eventually capitulate as well. England, Canada, those are possible. Germany, I threw Germany in because I knew Ryan was going to ask a question about Germany. Germany can be rather difficult. my firm actually has a German lawyer who wrote an article on this, and I didn't think of it until today. So if anyone wants that article, just email me and I'll send it. But Germany's like every country in Europe and pretty much every country around the world, and that is they don't really like U.S. judgments either, and they particularly don't like U.S. tort judgments, and they particularly don't like big U.S. tort judgments. So it may be possible to pursue some of these companies in Germany, but I think it's going to be difficult as well. And also, these companies that made the drywall are not German companies. One of the speakers did earlier today, I saw the list of all the companies. I noticed one was called NAF, Tianjin, one was NAF, Dongguan, I think the other one was NAF, Wuhan. Those are 3 cities in China. If you're going to have a real Chinese company, your name is always going to have the name of the city in the name of the company. So those are real Chinese companies. They may be 100% owned by a German company, but those are not representative offices. Those are independent Chinese companies. And so I don't know what the law is in Germany about going up the chain when you sue a subsidiary, but I think you'd have difficulty if you were bringing this claim against a U.S. company. So I don't think it's necessarily going to be a good thing. The UCLA rule. I learned this rule probably 10 years ago where I was at a China seminar and somebody told me that everybody in China wants their kid to go to UCLA. And so he said, find out where they want their kid to go to college and just keep talking about the college as though you have connections there. And it's kind of funny because it was UCLA that this guy talked about, and recently on behalf of a New Zealand company, I am convinced that my always talking about UCLA caused the Chinese company to settle. I would just sit there and talk about my daughter has a good friend on the UCLA basketball team. I know the dean of I know a professor in their East Asian Studies department. And every time I would talk, he would look a little bit panicked. And the reason is because this is how Chinese companies think. And I say companies because, as I said earlier, they're run by one person, and that one person wants his son or daughter to go to UCLA, and if you keep talking about it, they're going to think that you'll be able to stop it. And so keep talking about it. The other thing you should talk a lot about is customs and travel, because they want to ship their product into the U.S. and they want to come here to visit. So just keep talking about how when you were meeting with the customs officials or the passport officials, because they will get worried that somehow or other you have some major pull that you don't have. Seizing ships. There was a plaintiff's lawyer I saw who was talking about how he was going to start seizing the Chinese ships that brought the drywall into the United States. That is never, ever, ever going to happen unless some judge has decided that he or she does not want there to be any more international trade again, ever. Maybe you could seize a Chinese ship if it's owned by the same company as the drywall manufacturer, but I doubt that you'll find such a ship. But you're not going to seize the ship that brought it in. I've also read that there have been attempts to get the Chinese government to pay some of these claims. That's not going to happen either. Maybe the Chinese government will throw $5 or $10 million out there as a PR gesture, but I don't see them doing anything more than that. I don't even really see why they should, especially since we're always telling the government, or at least in the pre-Obama days, we're telling the government to get out of business. And that's what we were telling China, and the Chinese government has taken it to heart, and they've said, for instance, on IP, why are you complaining to us? Sue these companies. It's not the government's responsibility, it's the responsibility of the companies that do business with our Chinese companies. So I don't see that happening either. Saw this article talking about a bill before Congress where it's going to get the Chinese companies to agree to abide by U.S. law and to have an agent in at least one state. That's all great. I don't see how that would change a single thing. Thank you. Any questions?